I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are presenting you with our 43rd compilation of some of the classic moments we have had here on the channel. And before I give you the rundown on the different judges we will be seeing today and the different courtrooms we will be in today, let me just let you know there will be no commentary added to the end of these proceedings. There will be chapters added to the videos. And with that being said, thank you guys as always for joining me here on Sovereign Citizens Hall of Fame. Don't forget to like, share, subscribe, comment. It is all appreciated. Now, let me give you the rundown of the judges' courtrooms we will be in. First, we will be in the courtroom of Judge Kyra Dale out of the state of Idaho. Second, we will be in the courtroom of Magistrate William Burton Jr. and Magistrate Laura Echartea. They're going to be in a somewhat of a tag team type situation out of the state of Michigan. And last but not least, we will be in the 44th District Court, also out of the state of Michigan. I hope that you guys enjoy these proceedings. Once again, thank you for joining me. And with that being said, guys, let's go ahead and jump into this compilation.
At 8:15. And then just before that jury trial, there was a stipulation to continue filed. And then what I understood is that, the reason for that continuance was in part that your attorney, Mr. McCrill, was withdrawing his counsel of record. So it would be my understanding that we would need to take up the issues of whether or not you'd like a public defender, so your constitutional right to counsel, and then the issue of jury trial. I don't see that any other motions have been filed. So, Mr. Bowermaster, you kind of have two routes here. But the state has this charge against you, and both you and the state have a right to jury trial. So if we aren't going to resolve this via jury trial, what is it that you thought we were going to do today?
Oh, yes, I believe we had already covered the subject that I was auditing this process, and I actually do. So I feel that the court should be updated on the fact that this has reached a concern of immeasurable level for the people. And as the one that was elected to audit this, I am here to let you guys know that there have been multiple fails on multiple levels, but there is good news, and that good news is what I would like to present to the court now. So as regarding representing myself or anything along those lines, I just need the court to please bear with me. Behold, my eyes has seen all this, my ears has heard and understood this. What you know, I also know. I am not inferior to you. But I would speak to the Almighty, and I desire to reason with God. But you forgers of lies, you are all worthless physicians. Oh, that you would be silent, and it would be your wisdom, now hearing my reasoning and heed the pleadings of my lips. Will you speak wickedly for God, and talk deceitfully for him? Will you show partiality for him? Will you contend for God? Will it be well when he searches you out? Or can you mock him as one mocks a man? Will you he will surely rebuke you if you secretly show partiality. Will not his excellence make you afraid, and the dread of him fall upon you? Your platitudes are proverbs of ashes, your defenses are defenses of clay. Hold your peace with me, and let me speak. Then let come on me what may. Why do I take my flesh in my teeth, and put my life in my hands? Though he slay me, yet will I trust him. Even so, I will defend my own ways before him. He also shall be my salvation, for a hypocrite could not come before him. Listen carefully to my speech, and to my declaration with your ears. See now, I have prepared my case. I know that I shall be vindicated. Who is he who will contend with me? If now I hold my tongue, I perish. Only two things do not do to me. Then I will not hide myself from you. Withdraw your hand far from me. and let not the dread of you make me afraid. So this court should know that the good news is coming. And if you should be interested in who is representing me, that is Jesus Christ, my Lord and Savior. And I've been asked to address the court today that everyone can be forgiven through repentance. And if you wish to have any further communication or address anything further, that will be with my counsel, Jesus Christ, my Lord and Savior. And all proceedings going forward and hearings, Jesus Christ will be appearing for me, as that is the law. So if there aren't any further questions for me, I would ask this court to consider what I've asked. And if you need any contact information for said counsel, I will be happy to send it to any address that the court has on file.
I do have a couple of questions. When you say you're auditing this process, what does that mean, that you're auditing the process? I just am not following.
Well, I guess at this point I could share that there are violations and deprivations of rights. Unfortunately, we have those in this county that should have prevented these proceedings from even happening. So this process is null and void from its inception for the fact that statutes that are in place are not to be used against the people. The Constitution is not to be interpreted for the benefit of the state. And there are many, many things that we could cover, but I don't know that you want to use your time on that now. This is why I have suggested to the court to address my counsel going forward if there's any other questions.
Okay, I'd like to do a couple of things. Number one, I am going to appoint the public defender's office in this case. I'm going to do that based on your earlier application for the public defender.
I don't authorize that.
I hear you. From October 30th of 2020, you filed an application for public defender with the court.
Correct. That was part of the audit process.
Based on the representations in that application and concerns I have regarding your ability to represent yourself effectively in this case, I'm going to appoint the public defender's office.
I won't be representing myself as mentioned, Judge. That will be Jesus Christ, my Lord and Savior.
I don't have a way to communicate. It doesn't work here.
As I mentioned, I can refer anyone to the contact information for Jesus Christ if that is needed.
Okay.
It is available. Jesus is available to everyone right now. And if you do need contact information, I do have it for you. I'll even put it in the Zoom chat if you'd like.
Okay. So, Mr. Bowermaster, there are a couple of things with you stating that Jesus is your attorney. Number one, I don't want to be disrespectful of your belief system. You're entitled to that, and that should be honored. But the second thing is, it does raise concerns to me regarding how we are to move forward in this case if that's your position, that Jesus Christ is your attorney. It doesn't work that way here. There's nothing for us to work with here in the court. And then the third concern I have, and I do want to emphasize that I want to respect your belief system, but it makes me concerned regarding your competency, because I don't know what you expect us to do with that information. I don't know if you are hearing a voice. I don't know, and I can't help you. I'm not in a position to give you.
No, you can't.
Advice. All I can do is appoint an attorney to help represent you. So if there are issues regarding competency, those can be brought to the court's attention. Also, if you do act out in court, I have concerns that your right to be present at your own trial, that you could waive that by virtue of your conduct at that trial. So I at a minimum want to have backup counsel appointed in this case.
It sounds like you're subverting what I've already established in the court today. As a matter of fact, that was established by my attorney. I was just given the instructions that I could share that with you at this point as we do this transition. There is no question of competency. There's no question of whether or not that works for this court. This court is ran by God's law. As a matter of fact, everyone takes an oath, I believe, before God. And Jesus Christ is here today in this case, letting you know that if you decide to proceed, you will be facing Jesus Christ, not me. That is the counsel of this, of anyone who is put in a position of unlawful proceedings. And I don't, like I said, I don't claim to be the one with the answers. That's why I have this counsel. And I imagine you guys probably understand that, as you've expressed multiple times. It's extremely difficult to represent yourself. I've been shown the same. This world is not set up for that, nor is this court. And that is exactly why I must refer you to my counsel going forward. And a public defender will not be able to take the place of Jesus Christ, because that wouldn't be permitted by God's law. And going forward, if anyone feels that there's any questions about the validity of this case, I'm sure that you can refer to my counsel to explain to you why this case should be dismissed.
Okay, there haven't been any motions filed for the court to take up.
The spoken word is that, ma'am. And if Jesus feels that any motions need to be placed any further, I'm sure that will be done going forward.
So
I can't speak for Jesus, though.
Well, and that's the issue, right? Because certainly that no one can. And so we aren't going to have a very good record of what your attorney presents in terms of a defense on your behalf. So Ms. Mon, with all of this information, I'd like to, as I already said, I'm going to appoint the public defender's office over Mr. Bowermaster's objection. And I think you both might want to know, Mr. Bowermaster, that currently, at least for beginning not this week, but the following week, there's been another order that jury trials aren't going to proceed. So I can proceed in one of two ways. I can either set this for another status conference, but I think that's just delaying. I don't think that that would be helpful. I think what I need to do is get this on the jury trial calendar with the status conference in anticipation of that jury trial. And did you want to be heard otherwise, Ms. Mon, or otherwise make any statements for the record?
No, Judge. The state would request that this case be set for jury trial at this time.
Okay. You know, if we could hear your attorney could speak on your behalf, but I'm not.
Then maybe we should have a whatever you require so that you can hear Jesus. I'll make sure that that happens.
All right. So what
would that take?
What we'll do is we're going to set this for a jury trial.
Judge, did you hear me? I don't know if the audio's getting through.
No, I heard you. You asked me what it would take for us to hear from Jesus.
What would you need on that? Could I send you some contact information so you can speak with him?
No. I think at this point.
Are you denying Jesus Christ in this courtroom today?
No, I don't think that I would. I don't have any authority to do that. Right. And also, Mr. Bowermaster, based on your conduct today, I do think that this is more of a way for you to toy with the court than it
Absolutely
really is.
not. That is a disrespect, I think, to Jesus Christ.
An issue of competency. That's kind of where I'm coming down on this one. But I'm trying to find a good date.
Well, that's between you and Jesus. If you choose not to hear him, I have no judgment on you whatsoever.
All right. I'm going to set this for a jury trial, Ms. Mon. I'm going to do it on October 7th, which isn't a normal jury trial date on this calendar, but it's one that I feel that I could honor better. And I think it's important that any jury trial date we give Mr. Bowermaster, I'm going to use whatever power and authority I have to maintain that date. I really like to maintain that and give him priority.
What's his name?
The beneficiary.
Yeah, first name is the beneficiary.
Are you stating that the trust that we are administrating is the Kevin Pollard Trust? If so,
I'm asking you what your name is.
my name is the beneficiary of the trust.
Of whose trust?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor?
Okay, I'm
If
gonna
so,
recall him. Bring up somebody else. Put him aside. We'll call him at the end.
Thank you, Judge.
Sir, is your name the beneficiary, Kevin Teron Anthony Pollard? Yes or no?
I'm the beneficiary of the trust, Your Honor. Are you stating that the trust that we are now administrating is the Kevin Pollard Trust?
Are you Kevin Pollard? I'm asking you.
Is the trust that we are now administrating?
Sir, I ask the questions here. You give me yes or no answers.
You're asking for my permission
I ask the questions. You give the answers. Is that clear?
It's very clear.
Okay, listen.
Yes.
Are you also known by the name of Kevin Pollard amongst other names? Yes or no?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor? If so, Kevin Pollard is in fact present today. It is you that is Kevin Pollard, Your Honor. It is you.
Really?
Yes, Your Honor.
Really?
It is you. That is Kevin Pollard. Yes, Your
I'm
Honor.
Kevin Pollard.
You are Kevin Pollard today, Your Honor. I am the beneficiary.
And then who are you?
I am the beneficiary of the trust.
Okay, well, Mr. Beneficiary, take you and your trust back to jail.
I have some questions for the clerk, Your Honor.
No.
I have. Can I speak to the clerk before we go any further?
You know what? I'm gonna put you in timeout. Get your mind right. Mr. Pollard?
Yes, sir. Can I have the clerk present? Please, Your Honor.
Don't give in.
Please have the clerk present in a Zoom meeting.
You know what? If you answer my questions, I'll consider it.
Okay. What's the question?
What's your name?
The beneficiary.
All right, Mr. Beneficiary, put you back in timeout. All right, beneficiary. I'm going to give you another chance in front of another magistrate.
That's no problem. Can I have the clerk present, please?
Hey, sir, I'm Magistrate Echartea.
Excuse
DDC.
me? Yeah.
I'm talking to the DDC officer.
Yes.
DDC?
Yes, ma'am.
Okay. The gentleman that is in front of the screen, in front of camera one, what name do you have him listed as?
Kevin Pollard.
Do you have a middle name?
No, ma'am.
Okay, so you have a Kevin Pollard. Okay, and sir, you're identified as Kevin Pollard, but you're considering yourself the beneficiary. Is that correct, sir?
Are we on the record?
We are. Everything is on the record.
Okay. Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, ma'am?
I'm not administrating any trust because there is no trust in front of me. But what I'm asking you is, you call yourself the beneficiary. Is that correct?
Yes, Your Honor.
Okay, no problem. I have case number is 240-5538101. People of the state of Michigan versus Kevin Theron Anthony Pollard, who
Your
is
Honor,
listed by DDC as Kevin Pollard. However, the gentleman has identified himself as the beneficiary.
You representing as Kevin Pollard today, Your Honor.
Mr. Pollard,
I'm not.
Mr. Pollard, now as your counsel, I am going to advise that you stop speaking and allow the judge to speak.
Yes, ma'am.
Counsel Kirkland.
Good afternoon, Your Honor.
Thank you.
Shava Kirk on behalf of Mr. Pollard, who has been advised of his rights, wishes to stand mute and waive the formal reading.
Thank you. I'm going to enter plea of not guilty. February 2nd, 2024. It is a probable cause conference, followed by preliminary examination, February 8th, 1:30 p.m. Both matters are in front of Judge King. The probable cause conference, it is at 8:30 in the morning. Mr. Beneficiary, you should not talk over to the court. I thank you very much.
You are under oath and you are on record. And I'm asking you,
Beneficiary, I have not sworn you under oath. I am under oath, so I am doing all this. I'm going to enter plea of not guilty. I already given the court dates while this case is pending, sir. Okay, there should be no contact with the individual.
You are not allowed to state what the judgment is. That is my job.
Mr. Pollard, I do want to let you know that the person.
Okay.
I have a question for the clerk.
Okay.
I have a question for the clerk. I have a question for the clerk.
You will give an opportunity, sir. You will give an opportunity. Let me finish. While this case is pending, there's no contact with that means no person contact, no contact with third parties, no phone calls, no emails, no text messaging. The people, go ahead, Esteban.
Yeah, the people are asking for $250,000 cash bond, no cash, no surety. If he's able to ever post bond, we'd like GPS tether with home arrest. The defendant, Your Honor, has a continuing situation where he entices young girls on the internet from Arizona in this particular case, and previously on 10/23/2023 in another case where he enticed people. He's been arrested 3 different times for criminal sexual conduct. The first case, he was found not guilty back on 5/15/2015. The 10/21/2023 case, where he was criminal sexual conduct first degree and also contributing alcohol to a minor, 2 counts of that, was at the exam dismissed without prejudice. My belief in all that is because these victims all live out of state. In our particular case we have here today, Your Honor, the victim is from Arizona. She came here after having a relationship, not the victim, but one of the witnesses came here after having a 3-year relationship with this defendant on the internet. When she turned 18, she came to visit. And also, Mr. Pollard introduced her to another girl who is also from Arizona. The other girl brought her niece or her, I forgot the relationship, but her 7-year-old niece with her to visit Mr. Pollard. And what happened then, because the person was tired from traveling, she fell asleep in the living room. When she woke up, she went into the bedroom, and there was Mr. Pollard with the 7-year-old girl. He then said, "What are you doing?" And he says, "Well, we're playing video games." So the woman, the adult in the room, she falls asleep again. And then she is awakened by the 7-year-old girl and asked to leave. The 7-year-old girl then tells her mother that Mr. Pollard touched her, rubbed her, he says, okay? He said, accidentally is what he's trying to tell us what happened. The situation is she's told, the 7-year-old child has told TED Talk that he did this. He's told Protective Services that he did this. And as far as I'm concerned, Judge, he fits the category of a predator because he did the same thing in the 10/23/2023 case of enticing young people from other parts of the country, perhaps, I don't know where exactly, to come and see him on the internet. So we're asking for $250,000 cash bond, no surety, and GPS tether if he's ever be able to post bond, Your Honor. Thank you.
Okay. One question, Counsel Ragnan.
Yes.
Does he have any pending cases?
Not that I know of, Your Honor. The 10/23 case, 10/21/2023 case has been dismissed without prejudice at the exam, and I couldn't find out it was because if the witness was out of town or what the problem was. But
okay.
Thank you.
Thank you. Okay. Counsel Kirkland, go ahead, Esteban, please.
Thank you, Your Honor. I'd ask this court, understanding the seriousness of these charges, for a 10% bond if this court is not inclined to do a high personal bond, So one, I know the bulk of Brother Counsel's argument was this dismissed case from last year. I'd ask that this court sentence him based on these allegations and the facts and details surrounding this case. This is a 2020 case. And the woman that he met was 20 years old, or that came to see him was a 20-year-old woman, was not an underage woman. And the allegation is that she brought her, I believe, goddaughter to the home. Now, there are different variations because a couple different stories are told as to what occurred there. But Mr. Pollard has maintained that he didn't actually assault the little girl. I'm not sure why this case wasn't charged until 2024, but it is a 4-year-old case. My understanding is that he, I don't believe he's had any convictions since then. He is a lifelong resident, has a child, so he has strong ties to the community. He also owns a lawn service here. At this point, there's no amount of bond that he can't afford to pay, so even a 10% bond would be unaffordable for him. But given the age of this case and his lack of issues since this, I'd ask that this court consider a high personal bond, if not that, a 10% bond.
Thank you. I've heard the representations from both sides in this particular matter in reference to the beneficiary who is listed by the court or by DDC as Kevin Pollard, is that in this particular matter, even though this is from 2020, okay, there was a forensic interview, Kids Talk, with the victim, and she disclosed that she was touched by the defendant and that he rubbed her with his hand. This court is not considering the other cases that were dismissed without prejudice. Okay, this court is only going with this matter. In reference to this gentleman, the defendant, bond is going to be $250,000 cash. There's going to be a GPS tether, home arrest. Further, okay, it's going to be unaffordable. So today is Friday. He's going to get another court date. Today's the 26th, January 29th. 2024, 9 o'clock in front of Judge McConicle, who's going to be looking at the bond amount and bond conditions. Also, there is one other thing. This court looks at clear and convincing evidence standard, okay, based on the representation, based on the reading. This court is convinced that Mr. Pollard, okay, I'm sorry, the beneficiary, okay, that he is a creditor in this particular matter. That's why we're putting at $250,000 cash, GPS tether, house arrest. He does have the unaffordable bond redetermination for this Monday, January 29, 2024, 9 o'clock in front of Judge McConicle. Also, there's another bond condition. He's not to be around any minor children. That concludes the arraignment of the beneficiary, also known as Kevin Pollard. Madam Clerk.
Pre-trial, Your Honor.
No, I was
Talk to the gentleman that's in front of the screen.
Judge.
Okay. Just so for the record, is that the clerk has declined to talk to the gentleman in front of the screen.
No, that is not fair.
Thank you.
That is not fair. You cannot do this. Under oath and on record, you cannot do this. I have rights, and you violated them, and you was not my judge.
Okay, you go. Go ahead and do whatever.
You cannot do that.
Okay.
As the beneficiary, I asked.
I'm sorry.
Can we have those dates again? We couldn't hear them.
Over the dates.
February 2nd, February 8th.
February 2nd, February 8th. Bond redetermination Monday.
Of this QV trust account that she are.
Huh? What you say?
People versus Robert Shaw.
Very good, yeah, people.
We're here by special appearance, Your Honor, and remain in honor and not to argue but to challenge authority.
Your name?
Showman Robert Lewis.
Okay. This is the date and time set for a preliminary exam. Mr. Chauvin appears here on his own. As we've done in the past, Mr. Chauvin, I need to make sure you understand your rights today with regards to the potential to be represented by counsel. We've had this conversation before, correct?
I do not consent to any statutory authority presumed by this court.
Okay. We've had that conversation before about your right to have an attorney?
I am representing the all caps name, Your Honor. I am the attorney.
Okay. Do you want to have an attorney assigned to you?
No.
All right. You understand that if you wanted to, the court would have the Michigan Indigent Defense Counsel assign you.
I understand that.
Okay. You understand also the challenge or the crime that you're charged with?
Yeah, I don't understand.
The maximum penalties? It's a felony charge of non-sufficient funds check that occurred on or about May 31st, 2024. Maximum penalty is up to 2 years in prison and a $2,000 fine or 3 times the amount payable, whichever is greater. You've heard all of those maximum penalties before?
I have.
You have any questions about them?
No.
And having heard those maximum penalties, is it your request today to proceed on your own without counsel?
Yes.
Okay. You know that I have to treat you as if you had an attorney, correct?
Yes.
Okay. You know that I can't assist you in any way as we go through this hearing. You're going to have to question witnesses on your own to make the decision on whether or not you want to testify. You understand all that?
I do. Right.
You do? Yes. Okay. You do. But I won't be able to help you with that. Right. You understand that? Okay. Have you ever gone through a court hearing previously where you represented yourself? No. Okay. Have you looked into what a preliminary exam entails and exactly how this is going to go procedurally?
You briefly explained it to me last time we were here.
Okay. So do you have any questions right now about the process?
Well, my first question is, my question really regarding the whole thing is, I don't know if she is,
who's she?
The prosecuting attorney is capable of even speaking in this matter.
I'm not sure if that's what you mean. My question was about preliminary exam. I'll let you can make your motion here in a moment if that's what you're getting at, but do you have any questions about this preliminary exam?
No.
Knowing all that, all the understanding and explanation that I just gave you, your decision today to proceed on your own.
Yes. Yes.
All right. You want to bring up a couple issues?
Yes, I have an issue with the fact that under the bankruptcy of the United States of America, does the prosecutor have bonded fiduciary or sworn trust? Does she act as a prosecutor with bonding and act as a trustee for the United States? So is she able to do that?
Are you asking me a question?
Yes.
Okay, I'm not going to answer any questions. You have a motion that you want to make. Are you challenging something? And
yes,
saying that the court should move in one direction or another. I'll make a decision on that.
I would like to make a motion to challenge the validity of the prosecutor being able to prosecute this venue.
Based on what? I'll give you based on what?
Based on the bankruptcy of the United States of America.
Okay.
Because is she a trustee for the United States of America? That is my motion.
All right.
Thank you, Your Honor. Your Honor, I'm a licensed attorney in the state of Michigan. I am employed by the County of Oakland, and I have authority to exercise my prosecutorial duties within any district court within the County of Oakland. Furthermore, Your Honor, this charge is not anything that has been charged federally. Otherwise, there would be a federal prosecutor here. This is a county level from the city of Berkeley. So yes, I do have authority to move forward with these charges because the charges did come from my office, which is at the state level.
All right, and I've reviewed the complaint prior to today's hearing. It complies with the Michigan court rules and statutes that are at issue. Mr. Chauvin, you've made an objection. It's been being recorded on the record. The court's denying your objection, denying your motion. Have another motion you want to make? Are we ready to go?
Yes, I also have a motion for denial of process that this should not even be taking place because I was denied access to documents, records by making me pay for a fee for copies, which is against the Constitution.
What copies did you have to pay for?
Copy of records.
Which records?
My court filings.
Your court filings?
Yeah, I submitted.
You needed copies of the documents that you submitted?
Yes, certified copies.
Did you get those?
I had to pay for them.
Okay.
There should be a judicial notice, I guess.
I have something here with me. Did you get anything?
I did not, Your Honor.
Did you want to review this?
May I approach, Your Honor?
Any response to what he's talking about?
Your Honor, I mean, with regard to getting certified copies, everybody has to pay for those, so I'm not entirely sure where the issue lies. Furthermore, they're his documents, so I'm not entirely sure why copies were needed to begin with. So I also have nothing to do with whatever fees are issued by the court.
Sure. So those fees are again set by court rule and statute, and you know, your objection to the court imposing those fines, or not fines, but the fees to get the copies, those are overruled. The court's just following the court rules with regards to that. Your motion is denied with regards to the impact it may have on your due process. If it did have any impact, it would be a negligible one, given the fact that they were the documents that you had submitted. And the court register of actions would just simply confirm that they were actually submitted, which you could have also done by bringing your own second copy, having a true copy made, or a stamped copy returned to you that way. But in any event, I don't believe it has any impact on the way that we're going to proceed today. So again, you made your motion. There's a record of it. I denied it, and we're going to move on to the next. So do you have any additional motions?
Yes, I have one more motion. I think that this case should be totally thrown out because there was no legitimate warrant, sir.
No legitimate what?
Warrant.
Oh, warrant. Okay.
Which is why we're here in the first place.
No legitimate warrant.
No lawful warrant. I apologize.
Before I let you respond, what are your objections to the warrant that they would make it unlawful?
Well, I wasn't notified of a hearing to have the warrant issued, and under law, Public Act 1957, I'm allowed to be at a hearing where a warrant is issued in my name.
Were you denied access to the hearing?
I've never received a notice.
Okay. All right. Continue.
Your Honor, the warrant was issued by the office. It was sworn to by the court, entered into the system. I believe that there is not only case law, but statute, Michigan law, that allows for that to occur without having the person being charged present.
I agree. I'm going to again deny your motion. You made a record of it though, and that's the court's ruling. So any additional?
No.
All right. Then everyone can have a seat. And did you want to call your anything from you?
Yes, Your Honor. I would just ask for a mutual sequestration. I'm not sure who this individual in the court is.
Okay. Were you? Who's in the court?
This is my wife.
Okay. Is she a potential witness in the case?
Your Honor, is this Kimberly Chauvin?
Yes.
She's listed on here as a witness, so I'd ask that she be sequestered now.
Okay. Any comments about that request?
She kind of helped me with counsel though, so.
Okay, she can't do that. She's not, is she an attorney?
No.
Okay, so she can't do that, so that's not a basis for me to deny the request. So the reason that we'll have everybody step out on both sides, so any of your witnesses except for the officer in charge would also need to be out in the hallway, is that all the testimony will then occur and I will be able to hear it and have that influence the way that they're going to testify. So on that basis, the motion to sequester witnesses is granted. So Ms. Chauvin, you need to step out in the hallway and we'll get you when it's your turn to come to the testimony. Okay? All right. Your first witness.
Thank you, Your Honor. People call Matthew McBride.
All right, so before you get seated, if you please raise your right hand. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth. I do. Have a seat. Once you do get seated, if you state your first and last name and provide the spelling of both for the record. Sorry. Oh, jeez. Can I break this? Oh, sorry. Tony's.
Sorry. Matthew McBride, MATTHEW MCBRIEN.
Go ahead and say you.
Thank you, Your Honor. Mr. McBride, where are you employed?
Credit Union 1 in Berkeley.
And what is your job?
I'm a teller.
I'm going to draw your attention to May 31st of 2024. Were you working that day?
Yes.
And are you familiar with a Robert Chauvin?
Yes.
Did you see him in the courtroom here today?
Yes.
Can you please point to him and identify something he's wearing?
I guess a pale shirt.
Thank you, Your Honor. Let the record reflect that the witness has identified the defendant. I'm showing you what's been marked as People's Exhibit 1. Please take a look at that. And is that a copy of the check that was provided to you on that date?
Yes.
Did he also provide a copy of his ID?
Yes.
And once he provided copies of the check and his ID, what happened next?
So he did, or I handled deposit, and then he wanted to do multiple cash withdrawals.
And did you provide the withdrawals to him?
Yes.
And how were they provided to him?
In envelopes, like different denominations.
Okay.
Usually asked for certain amounts in separate envelopes, so.
And it was cash?
Yes.
So the check that was provided to you, what was the amount on that?
It was 30,000.
30,000. Okay. And how many withdrawals were made?
7.
Okay. And what were the amounts of the withdrawals?
So one for $1,024, $960, $1,500, $600, $1,200, and $2,000.
Mr. Chauvin, you have the opportunity to cross-examine this witness.
I have no questions.
All right.
Your Honor, people call Jillian Taylor.
Ms. Taylor, before you get seated, if you'd raise your right hand. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes. Ms. Taylor, where are you employed?
Credit Union 1.
And is that in the city of Berkeley?
I used to be the manager in Berkeley. I'm now at St. Clair Shores, but I was, yes.
Okay. I'm going to draw your attention to September 5th. Did you contact, of 2024, did you contact Berkeley PD?
Yes.
Why did you do that?
Our risk management department sent over a packet to send down to them. So when they knew that, they just send it to the branch manager, we call and hand that over. It was, from my understanding, it was because bad checks had been passed and was causing us a loss. So they were sending that down.
And the person who had deposited those checks, were they notified to your knowledge?
I believe so, yes.
Okay.
Objection, Your Honor, as hearsay.
Did you provide a packet from your loss prevention to Berkeley PD?
Yes.
So you gathered everything up and gave it to them?
They gathered everything up. So they sent me the packet complete. I don't actually.
So you just, okay.
Yes, I just handed it over.
Okay, thank you. Your name.
All right, Mr. Chauvin.
Your name, nothing for this.
Mr. Chauvin, any questions for the detective?
Yes. Sorry. On the date we spoke on the phone, did you have any intent, or did you think I had any intent to defraud the bank?
Objection, Your Honor, calls for speculation.
Same.
All right, I have no more questions.
Mr. Chauvin, do you have any witnesses you are calling today?
No.
All right. Will you be testifying? And ask to bind over?
Your Honor, people who provide over in charge of any argument for vote.
Mr. Chauvin, any comments about bind over?
Yes. So to bind over is to go to circuit court, correct?
Correct.
Okay, so I do have one question though. In my attempt to cure debt, I attempted to deposit a bill of exchange, which is lawful, and they rejected it. So why is that not taken into consideration here?
Okay, so your argument is that you tried to cure the debt, and so for those reasons, the case should not be bound over.
Yes.
Okay.
Your Honor, I would just indicate for the record, you did testimony that the bill of exchange that was presented by Mr. Chauvin was indicated to be not accepted as tendered legally to the bank. Furthermore, Your Honor, that's a question of fact for the trier of fact.
All right. The court's heard the testimony from the witnesses today, the arguments of the parties. I find that the testimony provided by the two witnesses from the bank and the detective do meet the probable cause standard required at the preliminary exam to bind over this matter to the circuit court. Mr. Chauvin brought up a potential trial defense. That's an argument that you could make later on down the line. But as of today, that is a question of fact and whether or not that was an actual legal tender that you had provided. And it's not a basis to deny the bind over. So that's something that we'll continue to move on down the line here. I find that the testimony met the burden. So count one is bound over to circuit court for further proceedings and box to you.
I'm not threatening you. Say one more word and that's 30 days. 30 days.